If you get a runway extended this side, we need not chop off this. So what are they talking today? Again, another obstructions?
You have been appointed
Amicus, my lord. Amicus, right from day one, my lord. My lords will see the reports, my lord. We have gone and make some field studies of the Paro International Airport, then Leh International Airports, my lord. The reports are there on the reports, my lord. This will speak volumes, my lord.
Port Blair is also there.
Port Blair is also there, my lord. Of course, Port Blair may not be very relevant, but the Bhutan and the Leh International Airports, my lord.
Yes. We have heard Mr. K. Khan, Additional Advocate General, Dr. N. Mozikar, Deputy Solicitor General of India, and Mr. Yobin, the learned advocate and amicus curiae appointed by the court in this application. By our order paragraph, by our order dated 30th April 2025, made in this public interest litigation concerning development and expansion of the Shillong Airport. We had directed a report to be filed by the state government and the central agencies with regard to the action taken in terms of previous orders passed by this court. Learned Additional Advocate General made submissions with great force and responsibility to explain why till this date the acquisition of land has not been made by the state. No, acquisition by the state has not been made of the required land to facilitate this expansion and development. Full stop. He submitted that the process of acquiring land has been initiated, but cabinet approval is awaited and is likely to be made soon. Full stop. What we have understood from submissions made earlier is that land acquisition to the procedure in the Land Acquisition Act would take an inordinately long time, and that for the purpose of speedy acquisition and handing over of the required land to the airport authorities, land would have to be acquired by the state government through private treaty with individual owners. We only observe and direct that the matters of formalities to be observed are with the state government, but what the court desires is that the land, no, that after observance of all formalities, the land should be handed over by the state to the airport authorities not later than 2 months from date. Full stop. If there is any obstacle or difficulty in compliance with this order, the state will bring it to the notice of this court by an application, when, if required, we shall appoint a special officer or commissioner to effect the purchase of land from the individual owners to the state, which in turn shall hand it over to the airport authorities. Full stop. Learned Deputy Solicitor General submits before this court that the Director General of Civil Aviation that that personnel from the Office of the Director General of Civil Aviation held meetings with the Shillong airport authorities with regard to some technical matters. Full stop. In that meeting, it transpired that there appeared to be some obstacles in the flight path to the airport, which were required to be removed by the state. Full stop. We direct the state government to hold consultation with the Director General of Civil Aviation and do the needful within the set period of 2 months. Thereafter, what will happen? After acquisition and removal of obstacles, then the infrastructure has to be built.
The tender has been floated for that, my lord. Because it's a big tender, my lord, more than 100 crore rupees. The financial bids the date for opening of financial bids is 17th of June, my lord. We are still receiving the bids, my lord, till 26th.
In the meantime, the central government shall go ahead with the tender process for building or renovating the
Runways.
yes, infrastructure to facilitate expansion of the Shillong airport, so that immediately on completion of acquisition of land, work in that behalf can commence. We make this application returnable on 15 July to receive separate action taken reports from the state government and the central government. Full stop. We express the hope that by 15th July 2025, this project concerning the Shillong airport will have made a substantial forward march. Full stop.
All right.
Much obliged.
Number 2.
Yes, yes.
This is the PIL concerning the stray dogs and the implementation of the animal birth control rules. My lords, have passed an order in pursuant to that, my lords. I've just been served with a copy of 2 meetings that the state government has held with the municipal authorities, my lords.
This is a report dated 8th May 2025, Your Lordships. It has been placed before Your Lordships.
Have you considered, Mr. Paul?
My lords, they say, my lords, the Shillong Municipal Board is to be the nodal authority, my lords, for these implementation of these rules throughout the state. My lords, to what extent that is possible?
We have also passed an order in this.
My lords, is the order dated 12/3/2025, my lords.
Your Lordships had directed us to hold a joint meeting with the Municipal Board and take steps to...
Yes.
The jurisdiction of the Shillong Municipal Board is, my lords, is restricted to only certain areas of Shillong.
in the municipal areas.
This is practically not possible, my lord, for municipal board because our territorial jurisdiction is very small area of the European ward in Shillong, my lord, and the normal Shillong. So, my lord, as far as our area is concerned, my lord, we give our assurance, we'll cater to it, my lord. But beyond that, my lord, we will not be able to.
If I may, my lords.
100. Meeting was held on 12th February.
My
No,
lords,
Your Lordship, that is not...
subsequent, my lords, at page
It was
4.
held on 16th April, Your Lordship. It is at
That
page
report
4.
has both these
At
reports.
page 4, Your Lordship. This 12 February meeting, that has already been placed earlier, Your Lordship. At page 4 of the same report, Your Lordship.
But till that time, what will happen? Till the acquisition of land.
Till such time, Your Lordship, that shelter home at Upper Shillong is being used, Your Lordship, belonging
That-
to the government.
But it will not be limited to 60 days. It will be extended.
It has to be extended. And the municipal board has also got their own temporary structure, Your Lordship, which they may have completed by now.
My lord, for our area, my lord, we will be able to cater, my lord. Beyond
to
that,
remove from the state shelter and put it in your shelter?
no, my lord. All stray dogs that are captured, we will, my lord, treat them, my lord, for any kind of ailment, immunization.
No, you had no shelter. So the state gave you shelter to keep 20 dogs.
My lord, that is created by us, my lord. We floated a tender. We have created in the municipal campus, my lord, in one of the quarters.
And the state has also given them a shelter, Your Lordship.
Yes.
Well,
Yes.
if I may, well, this entire exercise seems to be an exercise of putting the cart before the horse. Because the first thing that the state had to do is, my lords, under Rule 4, they had to form a committee. And, my lords, the committee is, the details of the committee are laid out, my lords. All stakeholders are basically made part of that committee under the rules itself. Once that committee is formed, my lords, then the things can actually start flowing. And then the state, my lords, you cannot appoint the Shillong Municipal Board as the nodal agency for the entire state. It would, the onus would lie on the state, the health department, veterinary and health department of the state, my lords, to create shelters in various areas. And also, my lords, have a program running in all these places. So these stray dogs, my lords, the issue can be addressed properly
Throughout the state.
throughout the state. And here, my lords, if I may submit that the district council would necessarily have to be made a party as well.
Yes, Your Lordship. That is what I was also thinking.
But it is for the state to first, my lords, notify the committee. If I may just take your lordship's, my lords, page 50 of my PIL, the constituent of the committee is, my lords, mentioned. If my lords have it, my lords.
Yes.
Page 50, if my lords kindly have a look at Rule 4, my lords. Formation of committee. A monitoring committee consisting of the following persons shall be constituted by the local authority, namely Commissioner, Chief of the local authority, who shall be the ex officio chairman of the committee, representative of the Public Health Department, representative of the Animal Welfare Department, a veterinary doctor, a representative of the District Society for Prevention of Cruelty towards Animal, at least 2 representatives of animal welfare organizations operating within the local authority, a representative of the people who is humanitarian, and a known individual. So this committee would have to be first notified, my lords, and I would humbly submit that there would have to be a representation from the district council also in this committee, because most of the areas would come within the district
Outside
council,
the municipal.
outside the municipal area. And, my lords, thereafter, the functions of the committee are also mentioned in Rule 5.
From 2001, no committee has been formed.
Nothing has been done, my lords.
All the deputy commissioners have to be made parties of district.
Lordships, they ideally,
That would be-
because they would be the head of the district, my lords, that would enable.
Easier to implement this
My lords.
rule, Your Lordship.
The state is already a party.
Yes, Your Lord. But the district
So-
council is also required because
You circulate to them.
we'll do that, Your Lordship. And the district council
Let
has to be
them
made
call for a
part.
meeting with all the stakeholders, my lords, and thereafter a proper report can be submitted, because otherwise these appear to be just governmental meetings, my lords. All the
With the
authorities are
municipal board
basically,
only.
well, it's the commissioners and the secretaries of various departments. That's it. The stakeholders are not part here. And the government would have to take the initiative of notifying a committee under Rule 4.
This public interest litigation invites this court to pass orders directing the state to take appropriate measures to control the menace posed by stray dogs, comma, to capture them, comma, treat them which would include sterilizing them and rehabilitating them in dog shelters. From time to time, we have passed orders to contain this menace. Paragraph. The scope and effect of our orders up to now has been confined to the Shillong district. Full stop. The Shillong Municipal Board did not have adequate facility to keep these stray animals. Full stop. Under orders of court, the state provided their shelter, their animal shelter, to accommodate these animals for a limited period. Full stop. Now it seems that the Shillong Municipal Board has been able to set up some kind of an animal shelter, but it cannot house all stray animals, stray dogs of the district. Full stop. Pursuant to orders passed by this court, meetings were held between the municipal authority and the state, as a result of which the state is to extend accommodation in its shelter the municipal board is to proceed with the acquisition of land for the purpose of building a further permanent shelter, after which the animals in the state shelter would be shifted to the municipal board accommodation. Paragraph. However, the petitioner in person points out that these measures by the court might not prove to be effective. Full stop. He has two reasons for this. Full stop. The first is that the order only covers the Shillong district. Full stop. The dog menace covers the whole of Meghalaya. Secondly, he draws our attention to the animal birth control within bracket dogs bracket closed rules 2001. Promulgated under subsection 1 of section 38 of the Prevention of Cruelty to Animals Act 1960. The rules have remained a piece of paper and never enforced. Mr. Paul points out that Rule 4 provides for formation of a committee comprising of the commissioner stroke chief of the local authority, who would be the ex officio chairman, the representatives of public health, animal welfare, District Society for the said Act, animal welfare organizations, and the comma, within quotation, humanitarian or a well-known individual. Paragraph. He contends that this committee be formed forthwith and discharges its functions as mentioned in Rule 5. These functions include the measures we have directed to be taken in respect of these stray animals. Our order, he says, should cover the whole state. In those circumstances, we observe and direct that the scope of this writ shall involve the whole of Meghalaya. The commissioners of the districts shall be served copies of the writ petition along with the orders passed therein by the advocate on record for the state within a week from date. The commissioners along with the local municipal authority will carry out our orders with regard to the Shillong district. In their districts, to the extent they would be applicable. The state government shall take immediate steps not later than 4 weeks from date to form a committee in terms of Rule 4 of the said rules within 4 weeks from date. Thereafter, the committee shall discharge its functions according to Rule 5. The state shall file a comprehensive affidavit with regard to the action taken before the returnable date. We make this writ application returnable on 16 July 2020.
May I make a small prayer, Your Lordship? Your Lordship, the District Council may also be made a party now so that they can also form a part of the committee, Your Lordship.
The state would do well to co-opt the district councils, my lords.
We have said you circulate the orders to the commissioners and the district council.
District council.
District Council, yes. In that case, it will cover the...
Otherwise, making all of them parties, you see, will make your task more
Yes,
difficult.
Your Lordship. So in that case, if Your Lordship adds the District
that
Council...
observe formality of service with each, that will delay matters. You serve them.
The commissioners and the District Council, if it is added, will serve our purpose, Your Lordship.
Yes.
Like,
Halim.
Number 3.
May I please, Your Lordship? But here the issue is, my lord. In this, my lord, writ of habeas corpus, my lord, the petitioner is seeking the protection of the minor child before this court and as well as, my lord, seeking her custody, my lord.
That matter.
That matter, my lord.
You made an application before the court.
I made application before the principal judge family court, my lord, but no order has yet been passed, my lord.
Then
And,
you wait for the order to be passed.
and secondly, my lord, earlier also during pendency of the proceeding before the family court, my lord, the respondent number 6, the wife, my lord, she did not participate, should proceeded ex parte, and my application was rejected by the family court, my lord. It was actually ex parte proceeding, my lord. So even if the family court also, my lord, pass any order, my lord, there
It
is
has got enough teeth, enough power to compel
my lord.
visitation and custody also to the father. So you first avail of that remedy.
My lord.
If there is some case which thereafter you can make out to invoke the writ of habeas corpus, we shall do so.
But at this stage, my lord, actually, my lord, at this stage, what is my lord grievances that even the visitation right granted by the family court, my lord, that has not been complied with by the wife, my lord, respondent, 6. My lord, where she kept my child, even my lord, she is hiding, my lord, hiding my child, my lord. That is the case here, my lord, for the purpose,
That happens in many cases.
my lord.
No, not so easily
Well.
visitation rights are honored. There are obstacles. The court knows how to.
Lordship. Lordship, then may fix a date, my lord, so that my lord.
Yes, we adjourn this matter till
On long date, my lord, so that in between
12 June.
12 June.
12 June.
Lordship.
To assess the development.
Lordship. All right, my lord.
Number 4 and 5.
Yes. 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 Yes.
You have better suggestion put forward.
You read paragraph 17. Now, before that, 17. Yes. Yes. Madam, we know all this. Please make your submissions on this point. That's all. Yes. No, why the other bidder was not made a party? You think? Why the other bidder was not made a party, you think? Why? Why? Two thousand
It is well
2007?
settled that a prerogative remedy is not a matter of course. In exercising extraordinary jurisdiction power thereof, A writ court will indeed bear in mind the conduct of the party who is invoking writ jurisdiction. His conduct of not making Mustafa Khar Kongar is very doubtful, Lordship. If the applicant does not disclose full facts or suppress relevant materials or is otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. The rule have been evolved in larger public interest to deter unscrupulous litigants from abusing the process of court by deceiving it. The very basis of the writ jurisdiction rests in disclosure of true, complete, and correct facts. If the material facts are not candidly stated or are suppressed or are distorted, the very functioning of the trick courts would become impossible. And only two-line judgment, relevant line in Ram Kumar versus State of UP.
No, this
prestige of the relevant and material
this prestige case. Prestige
Lordship?
case. What is the citation? This case,
Lordship,
prestige.
I'm not able to hear the voice properly from Lordship's ends, Lordship.
Prestige case. What is the citation?
Lordship?
My lord, that is 2007 8 SCC 449.
Yes, 2007 8 SCC 449.
See to it that it is. From here it is not going. From there
Para
it is.
35 to 36. The court's voice is, sound is not audible to me properly, Lordship. Paragraph 35, 36, Lordship.
Yes. Yes.
Shall I read it?
No, you have already placed it.
Lordship. Lord, there's another one, Ram Kumar 2023, 7 SCC 31. Held non-disclosure of the relevant and material documents with a view to obtain or an undue advantage would amount to fraud. Para 21.
Give the case.
It has been held that judgment or decree obtained by fraud is to be treated as a nullity. Now, Lordship, I'll come to the merits and the laws of my case. Lordship, the Tata Cellular have, in course of time, there are other judgments which has diluted the Tata Cellular judgment, Lordship. So I want to place before Lordship the relevant paragraphs. I want to read out the in Air India, Lordship, 2002 SCC 617. I'll just read, Lordship, and I'll just give the paragraph numbers, Lordship.
2002?
2002 SCC. 2002 SCC 617.
Yes.
Para 7.
What is the
and para
proposition?
11.
What is the proposition?
Lordship, I'm not hearing Lordship properly from the court's end.
Why? Who is in charge of this? Call him. Please wait.
Shall I read, Lordship?
Yes.
Para 7, Lordship. These are the 5 judgments I would like to satisfy, Lordship. Why? The Para 7, the law relating to award of a contract by the state, its corporations and bodies acting as instrumentalities and agencies of the government has been settled by decision of this court in so and so, so and so, so and so. Relevant para is on the 7th line. The award of a contract, the award of a contract, whether it is by a private party or by a public body or the state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are paramount are commercial considerations. The state can choose its own method to arrive at a decision. It can fix its own terms of invitation to tender, and that is not open to judicial scrutiny. It can enter into negotiations before finally deciding to accept one of the offers made to it. Here it says the authority can go into negotiations, Lordship. So calling us to negotiate among ourselves is not against the law, Lordship. It's already laid down in this case, Lordship. Law is laid down. The state can choose its own method to arrive at a decision. It can fix its own terms of invitation to tender, and that is not open to judicial scrutiny. It can enter into negotiations before finally deciding to accept one of the offers made to it. Price need not always be the sole criterion for awarding a contract. This is very important, Lordship. It is free to grant any relaxation for bona fide reasons if the tender conditions permit such a relaxation. It may not accept the offer even though it happens to be the highest or the lowest. But the state, its corporations, instrumentalities, and agencies are bound to adhere to the norms, standards, and procedures laid down by them and cannot depart from that arbitrarily. Though that decision is not amenable to judicial review, the court can examine the decision-making process and interfere if it is found vitiated by malafide, unreasonableness, and arbitrariness. Lordship, here I would say, calling us to negotiate among ourselves when we all have quoted the same base amount, is this an act of arbitrariness? Is it an act of unreasonableness? It's not, Lordship. The state, its corporations,
It's all right, madam.
and agencies have the
It's all right, all right. These are all general
all concerned. Even when some defect is found, Lordship is very important.
These are
Even
all
when
general
some defect
principles.
is found in the decision-making
Your
process,
thing does not work.
the court must exercise
You call
its
Vincent.
discretionary power under 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of a legal point.
Yes, put it on. Put it on. Not coming. You place it as the first matter tomorrow. We will hear it tomorrow, first matter. What's the other matters? People are checking.
Number 6.
Mrs. Parveen continues with her argument but does not conclude the same. List this appeal for further. These appeals for further hearing tomorrow. Put the date as the first matter in the list. Yes. Number 6. This one.
Number 6.
This will take some time, Mr.
Yes, Your Lordship. Your Lordship, I'm praying next week, Your Lordship. It will take some time, Your Lordship.
All right. On the prayer of learned counsel for the respondent, this appeal for further hearing on 19th.
Oblige, Your Lordship.
Number 7.
May it please your Lordship.
Yes.
Lordship, I beg to make, Lordship, I pray for some accommodation in this matter, your Lordship, as the senior conducting counsel, Didas, is indisposed, your Lordship.
All right. For the appellant.
For the appellant, your Lordship.
All right. Instead of respondent, appellant, same as the last matter, 19th.